Question 1, topic Clean Water Act and wetlands protection during a major transformation where existing methods of water pollution control are under review. A state legislature enacts a law that allows industrial facilities to discharge wastewater into wetlands provided they install certain filtration devices. A conservation group challenges the law, arguing that it violates the Clean Water Act. How should a federal court analyze the case? A. The state law is valid because it promotes industrial growth and balances economic and environmental interests. B. The state law is likely preempted by the Clean Water Act, which prohibits unauthorized discharge of pollutants into waters of the United States. C. The state law is constitutional because states have the exclusive right to regulate wetlands within their territory. D. The conservation group lacks standing to sue because there is no direct injury from the law. Answer. B. The state law is likely preempted by the Clean Water Act, which prohibits unauthorized discharge of pollutants into waters of the United States. Explanation. The Clean Water Act under 33 U.S.C. SS 1251 et seq. establishes federal jurisdiction over navigable waters, which include wetlands with significant nexus to larger water bodies. The National Pollutant Discharge Elimination System (NPDESA) prohibits the discharge of pollutants without permit. In Raponos v. United States, 2006, the Supreme Court reinforced federal oversight of wetlands. A. Incorrect. While economic interests are considered in environmental policy, the Clean Water Act prioritizes the prevention of water pollution over state economic policies. C. Incorrect. While states have some authority under Section 401 of the COU, they cannot override federal protections for wetlands. D. Incorrect. Conservation groups can establish standing under citizen suit provisions of CSS 500 provided they demonstrate environmental harm. Question 2, topic Environmental Impact Statements and NEPA while investigating a complicated issue between different federal agencies regarding a highway expansion project. An environmental organization claims that the Federal Highway Administration failed to conduct an adequate environmental impact statement as under the National Environmental Policy Act, NEPA. ABW argues that they conducted an environmental assessment and issued a finding of no significant impact. FONSI. Which of the following legal standards should the court apply? A. The court must defer entirely to the FHWAS finding unless clear evidence of fraud is presented. B. The court must independently review whether the highway expansion will have an environmental impact and substitute its own judgment. C. The court must determine whether hard look at potential environmental impacts before issuing the FONSI. D. The court should dismiss the lawsuit because NEPA does not provide private right of action. Answer. C. The court must determine whether a hard look at potential environmental impacts before issuing the FONSI. Explanation. Under NEPA 42 U.S.C. SS 4321 et seq. Federal agencies must conduct an environmental impact statement for actions significantly affecting the human environment. A hard look doctrine established in Robertson v. Methow Valley Citizens Council 1989 and Marsh v. Oregon Natural Resources Council 1989 requires agencies to thoroughly assess environmental consequences. A. Incorrect. Courts do grant deference under Chevron U.S. stating DC 1984 but still require rational basis for environmental decisions. B. Incorrect. Courts do not substitute their own judgment but review whether the agency complied with procedural requirements of NEPA. D. Incorrect. While NEPA does not create private right of action, lawsuits can proceed under the Administrative Procedure Act, Part 5 U.S.C. SS 706. Question 3, topic Corporate environmental liability and Superfund law. In an environment where different components must interact for environmental remediation, a company purchases land previously used for industrial waste disposal. Years later, the EPA discovers hazardous contamination on the site and demands cleanup under the Comprehensive Environmental Response, Compensation and Liability Act, CERCLA. The company argues it cannot be held responsible since it did not cause the pollution. What is the most accurate legal outcome? A. The company is not liable under CERCLA since it did not contribute to the contamination. B. The company is liable under CERCLA as a current owner of contaminated property, regardless of whether it caused the pollution. C. The company is only liable if it had knowledge of the contamination before purchasing the land. D. The company can claim exemption from CERCLA liability under the innocent landowner defense without any additional requirements. Answer. B. The company is liable under CERCLA as a current owner of contaminated property, regardless of whether it caused the pollution. Explanation. Under CERCLA 42 U.S.C. SS9601 etc. Also known as the Superfund Law, liability is strict, joint, and several, meaning that even innocent parties can be held responsible for cleanup costs. The Supreme Court in United States v. Best Foods, 1998, reinforced that current owners of contaminated sites bear responsibility. A. Incorrect. Circular liability is not based on fault. It applies to past and present owners. C. Incorrect. Knowledge of contamination is not required for liability under circular. D. Incorrect. The Innocent Landowner Defense 42 U.S.C. SS 9607b3 applies only if the buyer conducted all appropriate inquiries, i.e. before purchase under 40 CFR, Part 312. Question 4. Topic: Environmental litigation. Standing to sue in environmental cases while investigating complicated issue between different environmental stakeholders. Community advocacy group Green Future files lawsuit against local manufacturing company for alleged illegal dumping of toxic waste into nearby river. The company argues that Green Future lacks standing because they are not directly affected by the pollution. The group has members who live near the river and use it for recreational purposes. Green Future contends that the pollution has significantly degraded the water quality, harming both the ecosystem and its members' ability to enjoy the river. Which of the following best describes the legal requirements for standing in environmental cases and whether Green Future has valid claim? A. Green Future lacks standing because only individuals who own property adjacent to the polluted river have the right to sue. B. Green Future has standing because its members use the river for recreation and can demonstrate harm due to pollution. C. Green Future lacks standing because only government agencies can enforce environmental regulations in court. D. Green Future has standing only if they can prove that their organization and their individual members suffered direct harm. Answer: B. Green Future has standing because its members use the river for recreation and can demonstrate harm due to pollution. Explanation: standing to sue in environmental cases is a critical legal concept, often guided by the three-pronged test established in Lujan v. Defenders of Wildlife, 1992. Injury in fact. The plaintiff must show a concrete and particularized injury. In this case, Green Future's members use the river. Recreation, meaning they suffer direct harm from pollution. Causation: the harm must be traceable to the defendant's actions. If the manufacturing company is responsible for dumping toxic waste, this requirement is met. Redressability: favorable court ruling must be able to remedy the harm. If the court orders cleanup or penalties, this prong is satisfied. Answer choice A is incorrect because standing is not limited to property owners. Public interest groups can sue if their members suffer harm. Answer choice C is incorrect because while government agencies enforce laws, private citizens and organizations can file lawsuits under statutes like the Clean Water Act citizen suit provision. Answer choice D is incorrect because organizations can establish standing through their members under Hunt v. Washington State Apple Advertising Commission, 1977. Question 5. Topic: Climate change law, emissions trading systems and carbon pricing during major transformation where existing methods of industrial regulation prove insufficient. Federal government introduces new cap-and-trade system to regulate greenhouse gas (GHG) emissions. Under the program, companies are allocated limited number of emissions allowances, and those that emit less than their limit can sell excess allowances to companies that exceed their cap. Coalition of industry leaders challenges the policy, arguing that cap-and-trade unfairly burdens certain businesses and may not effectively reduce emissions. Which of the following best describes key legal or economic justification for emissions trading as climate policy tool? A. Cap-and-trade creates an economic incentive for businesses to invest in cleaner technology and reduce emissions at lower cost. B. Cap-and-trade is ineffective because companies can always purchase more allowances instead of reducing emissions. C. Emissions trading programs violate constitutional principles by placing price on the right to pollute. D. The system disproportionately benefits large corporations that can afford to buy more allowance, making it an unfair approach to climate policy. Answer: A. Cap-and-trade creates an economic incentive for businesses to invest in cleaner technology and reduce emissions at a low cost. Explanation: a cap-and-trade system is a market-based approach to reducing greenhouse gas emissions, widely used in programs such as the European Union Emissions Trading System (EUETS) and California's cap-and-trade program. The key justification is economic efficiency. Firms that can reduce emissions at cost can sell excess allowances, creating an incentive for innovation. Companies facing high compliance costs can buy allowances, ensuring emissions reductions occur where they are most cost-effective. The overall cap on emissions ensures that environmental goals are met. Answer B is incorrect because while companies can buy allowances, the overall cap limits total emissions, ensuring reductions occur. Answer C is incorrect because cap and trade systems do not sell right to pollute indefinitely. They regulate pollution under government oversight. Answer D is incorrect because while wealthier companies may buy more allowances, the system still encourages overall reductions and innovation. Question 6. Topic: Water law and environmental protection. Interstate water disputes and agreements in an environment where different components must interact to ensure sustainability. Two neighboring states, State and State B, dispute the allocation of water from major river that flows through both jurisdictions. State argues that its growing agricultural sector needs increased water withdrawals, while State B insists that excessive withdrawals harm downstream ecosystems and violate pre-existing watershed agreement. Which of the following legal principles or doctrines is most relevant in resolving this dispute? A. The prior appropriation doctrine, which gives priority to senior water users regardless of state boundaries. B. The public trust doctrine, which mandates that water resources be preserved for the benefit of future generations. C. The equitable apportionment doctrine, which seeks fair division of water between states through Supreme Court intervention. D. The riparian rights doctrine, which ensures equal access to water for all landowners along river, regardless of state agreements. Answer C. The equitable apportionment doctrine, which seeks a fair division of water between states through Supreme Court intervention. Explanation: Interstate water disputes in the U.S. are often resolved under the equitable apportionment doctrine, which grants the U.S. Supreme Court authority to allocate shared water resources fairly. This doctrine considers historical usage and pre-existing agreements, environmental impact of withdrawals on downstream ecosystems, economic needs of both states. Answer A is incorrect because the prior appropriation doctrine applies within individual states, not across state lines. Answer B is incorrect because the public trust doctrine primarily applies to navigable waters within a state, not interstate water disputes. Answer D is incorrect because riparian rights generally apply to private landowners, not to disputes between states. Question 7. Topic: Environmental justice. Community impact and policy response. During major transformation where existing methods of industrial regulation prove insufficient, residents of low-income neighborhood file lawsuit against waste disposal facility that has been operating in their area for decades. The residents argue that the facility has caused severe air and water pollution, leading to increased health issues such as asthma and respiratory diseases. However, the facility claims that it complies with all environmental regulations and provides essential services to the community. Which of the following legal arguments is most relevant for the residents in this case? A. The residents can argue that the facility violates the Environmental Protection Agency's EPA environmental justice policies, which prohibit placing disproportionate environmental burden on marginalized communities. B. The residents lack legal standing because the facility is operating under valid permit and regulatory compliance is sufficient to prevent lawsuits. C. The facility has right to operate as long as it meets regulatory standards, regardless of any disproportionate health effects on the surrounding community. D. The residents can argue that the facility is engaged in criminal negligence, even without proving direct harm to their health. Answer A. The residents can argue that the facility violates the Environmental Protection Agency's EPA environmental justice policies, which prohibit placing disproportionate environmental burden on marginalized communities. Explanation: The concept of environmental justice ensures that no community, particularly low-income or minority communities, suffers disproportionate share of environmental hazards. Key arguments in this case include EPA's environmental justice guidelines, which assess whether pollution disproportionately affects marginalized communities. Till Romans, the Civil Rights Act, 1964, which prohibits environmental policies that have discriminatory effects, even if unintentional. Landmark cases, such as Chester Residents Concerned for Quality Living v. Safe 1998, where environmental justice claims have been recognized in legal battles. Answer B is incorrect because legal standing can be established if the residents can demonstrate harm from pollution, even if the facility is compliant with regulations. Answer C is incorrect because compliance with environmental standards does not override environmental justice concerns. Answer D is incorrect because proving criminal negligence requires evidence of intentional harm, which is not necessary for an environmental justice claim. Question 8. Topic: Climate change law. Carbon emissions and legal obligations when implementing new protocols in shared environment to mitigate climate change. Group of states enters into regional agreement to reduce carbon emissions beyond federal requirements. However, major industrial corporation argues that these additional regulations violate the Commerce Clause of the U.S. Constitution by restricting interstate commerce. Which legal principle best addresses whether states can enforce stricter environmental laws than federal mandates? A. The Supremacy Clause prohibits states from creating any environmental regulations that exceed federal law. B. The Dormant Commerce Clause restricts state laws that unduly burden interstate commerce unless justified by legitimate local interests. C. States can only regulate carbon emissions if they receive explicit federal approval through the Environmental Protection Agency (EPA). D. The 10th Amendment gives states unlimited authority to regulate pollution within their borders, regardless of federal policies. Answer B. The Dormant Commerce Clause restricts state laws that unduly burden interstate commerce unless justified by legitimate local interests. Explanation: the Dormant Commerce Clause is a legal doctrine that limits state regulations that excessively burden interstate commerce. However, states can implement stricter environmental standards if they serve a legitimate local purpose, such as protecting public health or mitigating climate change. Key legal precedents include Massachusetts v. EPA, 2007, where the Supreme Court upheld state authority to regulate greenhouse gas emissions; American Trucking Assets v. Michigan PSC, 2005, reinforcing that state regulations must not unfairly discriminate against out-of-state businesses. Answer A is incorrect because the Supremacy Clause only applies when state laws directly conflict with federal laws, which is not necessarily the case here. Answer C is incorrect because states have independent authority under the Clean Air Act to set stricter emissions standards. Answer D is incorrect because the 10th Amendment does not grant states unlimited environmental regulatory power, especially when affecting interstate commerce. Question 9. Topic: Water law. Interstate water rights and disputes during comprehensive review of process that needs improvement. Two neighboring states dispute the allocation of water from major river. One state, located upstream, has significantly increased water withdrawals for agricultural use, causing reduction in water availability for the downstream state. The downstream state claims that this violates their legal rights and demands federal intervention. Which of the following doctrines or frameworks is most relevant in resolving this dispute? A. The reasonable use doctrine, which prioritizes water access for economic development regardless of downstream impacts. B. The doctrine of prior appropriation, which grants water rights based on historical first use, regardless of geographic location. C. The Clean Water Act, which directly regulates interstate water allocation disputes. D. The Safe Drinking Water Act, which provides federal oversight disputes involving access to drinking water. Answer B. The doctrine of prior appropriation, which grants water rights based on historical first use, regardless of geographic location. Explanation: the doctrine of prior appropriation is commonly applied in Western U.S. states granting water rights based on a first-in-time, first-in-right system. This means that earlier users have priority even if they are located upstream or in a different state. In Wyoming v. Colorado 1922, the Supreme Court upheld that prior appropriation governs water disputes between states. The equitable apportionment doctrine used by the Supreme Court in cases such as Florida v. Georgia 28. Answer D is incorrect because the Safe Drinking Water Act (SDWA) focuses on drinking water safety, not broader water use conflicts. Question 10. Topic: Environmental Impact Assessment. NEPA compliance and review. While analyzing the root causes of sequential problems in environmental permitting, federal agency approves highway expansion project without conducting an environmental impact statement. Environmental groups sue, arguing that the agency violated the National Environmental Policy Act (NEPA) by failing to assess potential environmental harm. Under NEPA, when is an environmental impact statement (EIS) required? A. An EIS is required for all federally funded projects, regardless of environmental impact. B. An EIS is required if the project has significant environmental impact, as determined through an environmental assessment. C. An EIS is required only if the affected community files formal petition requesting one. D. An EIS is never required if the agency determines the project meets all existing environmental regulations. Answer: B. An EIS is required if the project has a significant environmental impact, as determined through an environmental assessment. Explanation: the National Environmental Policy Act (NEPA) mandates that federal agencies conduct an environmental impact statement (EIS) for projects that may have a significant impact on the environment. First step: agencies conduct an environmental assessment to determine whether an EIS is necessary. If no significant impact is found, the agency issues a finding of no significant impact (FONSI). If significant impact is found, an EIS is required. Key case law: Robertson v. Methow Valley Citizens Council 1989 confirmed that an EIS must comprehensively assess environmental risks. Winter RDC 2008 emphasized that agencies must properly justify their environmental assessments. Answer A is incorrect because not all federally funded projects require an EIS. Only those with potential environmental impact. Answer C is incorrect because the requirement for an EIS is based on environmental impact, not community petitions. Answer D is incorrect because an EIS may still be required even if the project meets existing regulations, as compliance alone does not eliminate the need for environmental review. Question 11. Topic: Hazardous waste management. And CERCLA compliance when evaluating the implications of changing environmental policies. Manufacturing company is found to have improperly disposed of hazardous waste on its property. The Environmental Protection Agency (EPA) initiates an enforcement action under the Resource Conservation and Recovery Act (RI) and the Comprehensive Environmental Response, Compensation, Liability Act. CERCLA. The company argues that it was unaware of the hazardous nature of the waste at the time of disposal. Which of the following best describes the company's liability under CERCLA? A liability under CERCLA is based on intent, meaning the company is only responsible if it knowingly disposed of hazardous substances. B. The company is strictly liable under CERCLA for the cleanup regardless of its knowledge at the time of disposal. C. The company can avoid liability under CERCLA if it can prove that its waste disposal complied with state regulations. D. Only the current owner of the property, not past owners or operators, liable under CERCLA for hazardous waste cleanup. Answer: B. The company is strictly liable under CERCLA for the cleanup regardless of its knowledge at the time of disposal. Explanation: CERCLA, also known as the Superfund Law, imposes strict liability for environmental contamination, meaning that a company can be held responsible even if it did not intend to cause harm or was unaware of the hazardous nature of the waste. The law applies to past and present owners-operators of contaminated, those who arranged for disposal or transport of hazardous substances, those who accepted hazardous waste for disposal. Key case: United States v. Best Foods 1990 reinforced that corporate parents can be held liable for cleanup costs if they had control over hazardous waste operations. Answer A is incorrect because CERCLA liability is not based on intent or knowledge. Answer C is incorrect because compliance with state regulations does not override federal CERCLA liability. Answer D is incorrect because CERCLA liability extends to past owners and operators, not just current owners. Question 12. Topic: Clean Water Act. Wetlands and Section 404 permitting when considering the role of governmental oversight in enforcing environmental regulations. Real estate developer plans to build shopping complex on wetland. The U.S. Army Corps of Engineers denies the developer permit under Section 404 of the Clean Water Act (CA), arguing that the project will significantly damage protected wetland. The developer challenges the decision, claiming that the Clean Water Act does not apply to seasonal wetlands that are not directly connected to navigable waterway. Under current legal standards, which of the following statements best describes how wetlands are regulated under the Clean Water Act? A. The Clean Water Act applies only to wetlands that are permanently connected to navigable body of water. B. The Clean Water Act protects wetlands if they have significant nexus to navigable waters, even if they are seasonal or not directly connected. C. Developers are always allowed to build on wetlands as long as they offset environmental damage through mitigation measures. D. The U.S. Army Corps of Engineers cannot regulate wetlands unless Congress has explicitly designated them as federally protected. Answer B. The Clean Water Act protects wetlands if they have a significant nexus to navigable waters, even if they are seasonal or not directly connected. Explanation. Under Raponos v. United States, 2006, the Supreme Court ruled that wetlands do not have to be permanently connected to navigable waters to be protected under the Clean Water Act. Instead, they must have a significant nexus to navigable waters, meaning they water quality, ecosystem health, or hydrology. Key regulatory developments. The 2023 Waters of the United States WATUS rule further clarified how wetlands are regulated. The Sackett v. EPA 2023 case refined legal interpretations of wetlands under the COA is incorrect because wetlands do not need a permanent connection to be protected. Answer C is incorrect because mitigation does not automatically allow development on protected wetlands. Answer D is incorrect because Congress does not need to explicitly designate each wetland for federal protection. Question 13. Topic: Clean Air Act. Air quality standards and EPA regulations. While analyzing the effectiveness of current environmental regulations, the EPA revises national ambient air quality standards (NOx) under the Clean Air Act to lower allowable levels of particulate matter (PM.5) pollution. State government argues that the new standards are too strict and refuses to implement them, citing economic harm. What authority does the EPA have to enforce air quality standards against states that refuse to comply? A. The EPA has no enforcement power over states and can only issue recommendations. B. The EPA can impose sanctions, including loss of federal highway funding, on states that fail to meet NOx requirements. C. The EPA must obtain state consent before implementing any changes to air quality standards. D. States can set their own air quality standards without EPA oversight under the Clean Air Act. Answer B. The EPA can impose sanctions, including loss of federal highway funding, on states that fail to meet NOx requirements. Explanation. Under the Clean Air Act, the EPA has the authority to set national air quality standards and require states to create state implementation plans (SIPs) to comply. If a state refuses to implement the standards, the EPA can impose a federal implementation plan (FIP) directly enforcing regulations. EPA can withhold federal highway funding as a penalty. The EPA can impose stricter pollution controls on industries in non-compliant states. Key case: Train v. Natural Resources Defense Council, 1975, affirms that the EPA can enforce Clean Air Act provisions even if states resist. Answer A is incorrect because the EPA has direct enforcement authority under the CAR. Answer C is incorrect because states do not need to consent to changes in national air quality standards. Answer D is incorrect because while states can implement stricter standards, they cannot set weaker ones. Question 14. Topic: Endangered Species Act. Habitat protection and permitting. When considering the role of governmental oversight in enforcing environmental regulations, construction company plans to develop resort in an area designated as critical habitat for an endangered species. The U.S. Fish and Wildlife Service informs the company that under the Endangered Species Act (ESSA), the development could violate federal law by significantly altering the species' habitat. The company argues that it is not directly harming the species, but merely modifying the land. Which of the following best describes how the Endangered Species Act applies in this case? A. The company is not in violation of the ESSA because it is not directly harming or killing the endangered species. B. The ESSA prohibits both direct harm to species and significant habitat modification that could impair their survival. C. The ESSA only applies to government projects and does not regulate private landowners. D. The company can proceed with development as long as it implements voluntary conservation measures. Answer B. The ESSA prohibits both direct harm to species and significant habitat modification that could impair their survival. Explanation. The Endangered Species Act (ESSA) protects endangered and threatened species by prohibiting takeover species, which includes harm, hunting, or harassment, significant habitat modification if it could result in harm. Key case: Babbitt v. Sweet Home Chapter of Communities for Great Oregon. 95 confirmed that habitat destruction can be considered harm under the ESSA even if no individual animal is directly killed. Answer A is incorrect because the ESA applies to habitat destruction, not just direct harm. Answer C is incorrect because the ESA applies to both government and private actions. Answer D is incorrect because voluntary measures do not override ESA requirements. Question 15. Topic: National Environmental Policy Act. Environmental impact statements. While analyzing the effectiveness of current environmental regulations, federal agency proposes highway expansion project that will pass through sensitive wetland. Environmental groups challenge the project, arguing that the agency failed to conduct an adequate environmental impact statement (IS) under the National Environmental Policy Act (NEPA). Which of the following best describes the federal agency's obligation under NEPA? A. The agency must prepare an IS only if there is definitive proof that the project will cause significant harm. B. The agency must prepare an environmental impact statement (IS) if the project has the potential to significantly affect the environment. C. NEPA only applies to private development projects, not government-funded projects. D. The agency can bypass an IS as long as it consults with environmental experts. Robertson v. Methow Valley Citizens Council, 1989, confirmed that an IS must analyze potential environmental impacts, but does not require agencies to choose the least harmful alternative. Answer A is incorrect because an IS is required based on potential impact, not definitive proof. Answer C is incorrect because NEPA applies to federal projects, not private developments. Answer D is incorrect because consultation alone is not sufficient. An IS must be prepared. Question 16. Topic: Climate change law. Greenhouse gas regulation under the Clean Air Act. When evaluating the implications of changing environmental policies, the EPA introduces new rules limiting greenhouse gas emissions from power plants under the Clean Air Act. Industry groups challenge the rules, arguing that the CAA was not originally intended to regulate greenhouse gases. Which of the following Supreme Court decisions established that the EPA has authority to regulate greenhouse gases under the Clean Air Act? A. Massachusetts v. EPA, 2007. B. Chevron U. S.A. Inc. v. Natural Resources Defense Council, 1984. C. Sierra Club v. Morton, 1972. D. Raponos v. United States, 2006. Answer A. Massachusetts v. EPA, 2007. Explanation: In Massachusetts v. EPA, 2007, the Supreme Court ruled that the Clean Air Act's definition of pollutants includes greenhouse gases. The EPA has authority to regulate CAA and other greenhouse gases as pollutants if they endanger public health. This decision led to EPA regulations on vehicle emissions and power plant emissions, shaping U.S. climate policy. Answer B is incorrect because Chevron deals with agency interpretation of statutes. Answer C is incorrect because Sierra Club v. Morton is about standing in environmental lawsuits. Answer D is incorrect because Raponos relates to wetlands, not air pollution. Question 17. Topic: International environmental law. Paris Agreement commitments. While analyzing the effectiveness of current environmental regulations, nation decides to withdraw from the Paris Agreement on climate change, arguing that its obligations under the treaty were unfair. What is the legal status of the Paris Agreement under international law, and how does withdrawal work? A. The Paris Agreement is legally binding and countries cannot withdraw. B. The Paris Agreement is voluntary and countries can ignore their commitments without consequence. C. The Paris Agreement allows withdrawal, but only after country has been party for at least 3 years. D. The Paris Agreement requires countries to submit legally binding emission reduction targets. Answer C. The Paris Agreement allows withdrawal, but only after a country has been a party for at least 3 years. Explanation: The Paris Agreement is a legally binding international treaty, but its emission reduction targets are non-binding. Countries can withdraw, but only after being a member for 3 years. The withdrawal process takes 1 additional year, meaning a country must wait 4 years total before fully exiting. Example: the U.S. withdrew under President Trump in 2020 and rejoined under President Biden in 2021. Answer A is incorrect because withdrawal is allowed. Answer B is incorrect because while targets are voluntary, reporting requirements are binding. Answer D is incorrect because national targets are self-determined, not legally enforced. Question 18. Topic: Environmental justice. Disproportionate impact of pollution when considering the role of governmental oversight in enforcing environmental regulations. Studies show that minority and low-income communities experience higher exposure to pollution from industrial sites. These communities argue that environmental regulations are not being enforced equally. Which of the following best describes how environmental justice addressed under U.S. Law? A. Federal environmental laws explicitly require agencies to consider environmental justice impacts. B. The concept of environmental justice has no legal basis in U.S. environmental regulations. C. Executive orders and agency policies encourage consideration of environmental justice but do not create legally enforceable rights. D. Only state governments, not federal agencies, are responsible for addressing environmental justice concerns. Answer: C. Executive orders and agency policies encourage consideration of environmental justice but do not create legally enforceable rights. Explanation: Executive Order 12898, 1994 directs federal agencies to consider environmental justice impacts, but it does not create new legal rights. Agencies like EPA incorporate environmental justice into decision-making, but enforcement is case-dependent. Answer A is incorrect because federal laws do not explicitly mandate environmental justice analysis. Answer B is incorrect because environmental justice is recognized in policy, just not as a legal mandate. Answer D is incorrect because both state and federal agencies address environmental justice issues. Question 19. Topic: Clean Water Act. Definition of waters of the United States when evaluating the implications of changing environmental policies. The U.S. Army Corps of Engineers denies companies permit to discharge waste into seasonal wetland on private property, arguing that it falls under the Clean Water SATCO protections as part of the Waters of the United States, WATUS. The company argues that the wetland does not qualify as navigable waters and thus should not be regulated, which Supreme Court case significantly shaped the definition of waters of the United States on Clean Water Act. A. Rapanos v. United States, 2006. B. Massachusetts v. EPA, 2007. C. Sierra Club v. Morton, 1972. D. Chevron U.S. Inc. VOADC, 1984. Answer A. Rapanos v. United States, 2006. Explanation: In Rapanos v. United States, 2006, the Supreme Court limited federal jurisdiction under the Clean Water SATCO by ruling that only wetlands with a significant nexus to navigable waters fall under federal regulation. Justice Scalia's plurality opinion took a narrow view, requiring a continuous surface connection to navigable waters. Question 20. Topic: Clean Air Act. State versus federal authority in air pollution control. While analyzing the effectiveness of current environmental regulations, California adopts stricter vehicle emissions standards than federal rules. Auto manufacturers challenge the regulation, arguing that states cannot impose their own emissions standards under the Clean Air Act. Which of the following is true regarding state authority over air pollution regulation? A. The Clean Air Act completely prevents states from setting their own emission standards. B. States can regulate emissions only if the EPA grants them waiver, as it has done for California. C. States can set any emission standards they choose, independent of federal approval. D. States have no authority over vehicle emissions, only the federal government does. Answer B. States can regulate emissions only if the EPA grants them a waiver, as it has done for California. Explanation: Under the Clean Air Act, the EPA sets national emissions standards for vehicles. States generally cannot override these federal rules. However, California has a special waiver under Section 209B, allowing it to implement stricter standards. Other states can adopt California's standards, but they cannot create their own separate ones. Answer A is incorrect because California has waiver allowing stricter rules. Answer C is incorrect because only California can set stricter standards with EPA approval. Answer D is incorrect because states do have some regulatory authority when following federal procedures. Question 21. Topic: Resource Conservation and Recovery Act. Hazardous waste regulation. When considering the role of governmental oversight in enforcing environmental regulations, factory improperly disposes of industrial solvents contaminating local groundwater. The EPA cites the company under the Resource Conservation and Recovery Act. RA, which of the following best describes the purpose of RA? A. RA focuses on cleaning up hazardous waste sites after contamination occurs. B. RA regulates the management, treatment, storage, and disposal of hazardous waste to prevent contamination. C. RA only applies to federal facilities, not private companies. D. RA allows companies to voluntarily manage hazardous waste without government oversight. Answer: B. RA regulates the management, treatment, storage, and disposal of hazardous waste to prevent contamination. Explanation: RA 1976 is a preventative law ensuring proper hazardous waste management. It requires permits for hazardous waste treatment, storage, and disposal facilities. The Comprehensive Environmental Response, Compensation, and Liability Act (CERCLA) Superfund handles cleanup after contamination. Unlike RA, which is preventative. Answer A is incorrect because CERCLA, not RA, handles cleanup. Answer C is incorrect because RA applies to both federal and private entities. Answer D is incorrect because companies must comply with strict regulations. Question 22. Topic: National Environmental Policy Act. Environmental impact statements and public participation. While analyzing the effectiveness of current environmental regulations, federal agency approves major oil pipeline without conducting an environmental impact statement. Eyes under NEPA. Environmental group sue, arguing that the agency violated the law. What is required under NEPA before approving such project? A. The agency must prepare an EIS if the project is likely to have significant environmental impacts. B. The agency can approve the project without any environmental review. C. NEPA applies only to private projects, not federally funded ones. D. Agencies can choose whether or not to conduct an environmental review. Answer: A. The agency must prepare an EIS if the project is likely to have significant environmental impacts. Explanation: NEPA 1969 requires agencies to assess environmental impacts before approving major federal actions. Agencies must conduct an environmental assessment, and if significant impacts are possible, they must prepare an environmental impact statement. EIS. Public participation is required in the EIS process. Answer B is incorrect because NEPA mandates environmental review for federal actions. Answer C is incorrect because NEPA applies to federal projects, not private ones. Answer D is incorrect because environmental review is required, not optional. Question 23. Topic: CERCLA Superfund liability and site remediation. When evaluating the implications of changing environmental policies, landowner purchases property later discovered to be contaminated with toxic chemicals. The EPA holds the owner responsible under CERCLA Superfund. Which of the following describes the legal principle applied in CERCLA liability? A. Strict, joint, and several liability, meaning landowners can be held responsible even if they did not cause the contamination. B. Only companies that directly caused contamination can be held liable. C. The EPA can only fine companies, not require cleanup. D. Landowners can avoid all liability if they claim ignorance of contamination. Answer A. Strict, joint, and several liability, meaning landowners can be held responsible even if they did not cause the contamination. Explanation: CERCLA imposes strict liability, meaning no need to prove fault. Joint and several liability means any responsible party can be held fully liable for cleanup. The innocent landowner defense requires proving due diligence was conducted before purchase. Answer B is incorrect because liability applies broadly even to new landowners. Answer C is incorrect because CERCLA requires cleanup, not just fines. Answer D is incorrect because landowners must prove due diligence to avoid liability. Question 24. Topic: Endangered Species Act. Federal versus state authority and wildlife conservation. When analyzing the impact of legal frameworks on biodiversity conservation, state government authorizes new highway project that will disrupt the habitat of an endangered species, but argues that it has the right to manage wildlife within its borders. Environmental groups challenge the decision, citing the Endangered Species What legal precedent supports the federal government's authority over endangered species protection? A. Tennessee Valley Authority v. Hill 1970. B. Chevron U.S. Inc. in ADC 1984. C. Lucas v. South Carolina Coastal Council 1992. D. Solid Waste Agency of Northern Cook County v. U.S. Army Corps of Engineers 2001. Answer: A. Tennessee Valley Authority v. Hill 1970. Explanation: in Tennessee Valley Authority v. Hill 1970, the Supreme Court ruled that the Endangered Species Act (ESSA) takes priority over economic development. The snail darter case established that once a species is listed as endangered, federal agencies must take action to protect it regardless of economic costs. The ESSA applies nationwide, overriding policies that threaten endangered species. Answer: B is incorrect because Chevron dealt with agency deference, not species protection. Answer C is incorrect because Lucas focused on property rights and regulatory takings, not environmental conservation. Answer D is incorrect because Solid Waste Agency limited federal jurisdiction under the Clean Water Act, not the ESSA. Question 25. Topic: National Environmental Policy Act. Environmental justice and community impact. While evaluating the effectiveness of current environmental regulations, low-income community is disproportionately affected by proposed waste incinerator project. The government claims that the project meets environmental standards, but community advocates argue that it violates principles of environmental justice under NEPA. Requirement under NEPA supports environmental justice claims. A. Agencies must consider disproportionate impacts on minority and low-income communities when conducting environmental impact statements. Is. B. NEPA does not require any environmental justice considerations. C. Only the EPA can enforce environmental justice policies, not other federal agencies. D. Environmental justice claims are only valid if pollution exceeds federal limits. Answer: A. Agencies must consider disproportionate impacts on minority and low-income communities when conducting environmental impact statements. Is. Explanation: Executive Order 12898, 1994 requires federal agencies to identify and address disproportionate environmental burdens on marginalized communities. Under NEPA, agencies must evaluate cumulative and indirect environmental impacts, including social and health effects. Environmental justice is increasingly incorporated into NEPA reviews to ensure fair treatment and public participation. Answer: B is incorrect because environmental justice is now a recognized consideration under NEPA. Answer C is incorrect because all federal agencies must consider environmental justice, not just the EPA. Answer D is incorrect because impacts can be unjust even if pollution is within legal limits. Question 26. Topic: Clean Water Act. Non-point source pollution and state responsibility. When evaluating the implications of changing environmental policies, state faces rising levels of nutrient pollution in rivers due to agricultural runoff. Farmers argue that they should not be held accountable since their operations do not involve direct discharges into water bodies. Which provision of the Clean Water Act to this situation? A. Non-point source pollution is primarily regulated by state governments through best management practices under Section 319. B. The Clean Water Act does not address agricultural pollution. C. The EPA must issue direct permits to farmers for non-point source pollution. D. Agricultural runoff is regulated the same way as industrial wastewater under the National Pollutant Discharge Elimination System (NPDES). Answer: A. Non-point source pollution is primarily regulated by state governments through best management practices under Section 319. Explanation: Section 319 of the EOE provides funding and guidance to states to address non-point source pollution, which comes from diffuse sources like farms and urban runoff. Unlike industrial facilities, farmers do not need direct permits under the NPDES program, but implement state-approved pollution control measures. Answer: B is incorrect because AEA does address agricultural pollution through Section 319. And answer C is incorrect because the EPA does not directly regulate non-point sources. States do. Answer D is incorrect because agricultural runoff is regulated differently than industrial discharges. Question 27. Topic: Superfund liability. Brownfield redevelopment challenges when considering the role of governmental oversight in enforcing environmental regulations. Real estate developer buys an abandoned factory site for redevelopment only to discover toxic contamination. The EPA notifies the developer that the site is Superfund site under circular. How can the developer avoid liability under circular? A. The developer must prove they conducted all appropriate inquiries, i.e. before purchase, to qualify for the innocent landowner defense. B. Circular holds only the original polluter responsible, so the developer is not liable. C. The developer must clean up the site even if they were unaware of contamination. D. There is no legal way to avoid circular liability once site is designated as Superfund site. Answer A. The developer must prove they conducted all appropriate inquiries, i.e. before purchase, to qualify for the innocent landowner defense. Explanation. Circular imposes strict liability, meaning landowners can be held responsible even if they did not cause contamination. The innocent landowner defense applies if the buyer conducted proper due diligence, i.e. before purchase, had no knowledge of contamination, took steps to prevent further pollution. Answer B is incorrect because new owners can be held responsible under circular. Answer C is incorrect because owners can avoid liability if they meet certain legal requirements. Answer D is incorrect because circular includes defenses for innocent buyers. Question 20. Topic: Climate change law. Carbon emissions and federal regulation. When analyzing the impact of legal frameworks on climate change mitigation, the EPA issues new carbon emission limits for coal-fired power plants under the Clean Air Act, which Supreme Court decision confirmed the EPA's authority to regulate greenhouse gases. A. Massachusetts v. EPA 2007, B. West Virginia v. EPA 2022, C. Chevron v. ADC 1984, D. Utility Air Regulatory Group v. EPA 2014. Answer A. Massachusetts v. EPA 2007. Explanation. In Massachusetts v. EPA, the Supreme Court ruled that greenhouse gases are air pollutants under the Clean Air Act, allowing the EPA to regulate co-emissions. This decision established the legal foundation for federal climate policies. Answer B is incorrect because West Virginia v. EPA limited the EPA's authority over power plant regulations. Answer C is incorrect because Chevron dealt with agency deference, not climate change. Answer D is incorrect because utility air focused on permit requirements, not EPA authority. Question 29. Topic: Clean Air Act, air quality standards and state compliance. When evaluating the effectiveness of current environmental regulations, state with multiple industrial facilities fails to meet the National Ambient Air Quality Standards (NOx) for ozone pollution. The EPA classifies the state as non-attainment area requiring corrective actions. Which of the following actions must the state take to comply with the Clean Air Act? A. The state must develop state implementation plans (SIP) detailing how it will reduce pollution to meet NOx. B. The EPA must directly regulate all polluting industries in the state. C. The state can ignore NOx since air quality regulation is federal responsibility. D. The Clean Air Act does not apply to states, only private companies. Answer A. The state must develop a state implementation plan (SIP) detailing how it will reduce pollution to meet NOx. Explanation. Under the Clean Air Act, states must develop state implementation plans (SIPs) to achieve compliance with federal air quality standards. SIPs outline pollution control measures, industry regulations, and enforcement strategies to reduce ozone, particulate matter, and other pollutants. If a state fails to submit adequate SIP, the EPA can impose a federal implementation plan (FIP). Answer B is incorrect because the EPA oversees compliance but does not directly regulate individual industries within a state. Answer C is incorrect because states must comply with NOx even though enforcement is decentralized. And answer D is incorrect because states play a key role in air quality management under the Clean Air Act. Question 30. Topic: Environmental Impact Assessment. Major federal actions and NEPA compliance. When analyzing the impact of legal frameworks on large-scale development projects, federal agency plans to approve new oil pipeline across multiple states. Environmental groups argue that the project could cause significant environmental harm and demand more detailed review under the National Environmental Policy Act (NEPA). Requirement under NEPA applies to this situation. A. The agency must prepare an environmental impact statement (IS) because the project is major federal action significantly affecting the environment. B. The agency can proceed without review because private companies are constructing the pipeline. C. NEPA does not apply to energy projects. D. The agency can approve the project with no environmental analysis if it meets industry standards. Answer A. The agency must prepare an environmental impact statement (IS) because the project is a major federal action significantly affecting the environment. Explanation. Under NEPA, major federal projects that may significantly impact the environment require a detailed environmental impact statement (EIS). An EIS includes assessment of potential environmental consequences, consideration of alternatives to the project, mitigation strategy. To reduce harm, pipelines require federal permits, making them subject to NEPA review. Answer: B is incorrect because NEPA applies if federal approval or funding is involved, even if private companies construct the project. Answer: C is incorrect because NEPA applies to energy infrastructure, including pipelines. Answer: D is incorrect because NEPA requires a structured environmental review process, not just compliance with industry standards.